Good morning and welcome to the fifth and final of our weekly Meet the Experts Q&A sessions with Sintons Employment Team. My name is David Pritchard and I'm the Head of Marketing here at Sintons. Once again, and for a final time, can I just thank you all for signing up to these sessions, for tuning in each week, sending in your questions and watching the videos afterwards. It's been very much appreciated. As with previous weeks, the employment team are going to answer 3 questions, either COVID related or not, that you haven't quite got to the bottom of or that your employees are persistently asking you. Our speakers today, myself introducing, I'll just move the slides on so you can see their photos. Myself introducing, Head of Employment at Sintons Keith Land, and making a return is Associate Angela Carver. So without any further ado, I'm going to pass you straight over to Angela, who's going to start with question 1 of 3. Angela, good morning and over to you.
Good morning, David, and good morning, everybody. Thank you for tuning in to the last Q&A. It's almost quite sad, really, but hopefully that means that everything is going to start to get back to normal sometime soon. The questions that we've got, the first one I'm going to deal with is employees who refuse to return to the workplace. Now, we have covered off a lot of this in our seminar, which we did last week, which you can find on the Sintons website if you require more detail. But just as a generic overview, the key reasons people tend to be refusing to come back to work are childcare, their safety, pregnancy, and general fear. And I'm sure there's some people who just quite enjoy furlough, but that's not the excuse they're giving their employers. So in relation to those who've got childcare issues, first thing to look at is, can these employees work from home? Can you look at some flexibility in the working arrangement? Myself and Keith, like many, are all working at home with children. It's not ideal, but it tends to be the norm to hear dogs barking and children screaming for bagels in the background now. And I think we've all come to accept that. If an employee can't do their job from home, things you need to look at are what you can do with the working arrangement. Can you alter shifts? Can you have them doing evening work, weekend work, etc.? If not, all individuals with parental responsibility are entitled to unpaid parental leave. That's up to a maximum of 18 weeks per child, and also emergency time off for dependents. Bear that in mind. Final point on childcare is, if you put an arrangement in place which puts a woman at a disadvantage, women tend to be the main childcare providers, you could look at an indirect discrimination claim unless you can justify the working arrangement. Overall, with childcare, talk to your employees, find out the difficulties, see if you can find a workaround. Safety is a big one. Every employer who's got more than 5 members of staff needs to have a written risk assessment dealing with COVID-19. If you've got more than 50 staff, you would expect to see it on the website as well. Your risk assessment should deal with things like keeping staff 2 meters apart, reducing workplace density, frequent cleaning of your premises, the expectation on staff, for example, laundering uniforms, frequent hand washing. You need to make sure you provided washing facilities which are suitable. And you need to, again, look at, can you put one-way systems throughout your business? Can you restrict people in the communal areas? Reduce interaction pre and post shifts. And if you've got shops or retail, look at key management restrictions in the shops. When you've looked at all of that, if you can't keep your staff 2 meters apart, you need to look at things like PPE, like visors, or back-to-back working, things like that. If you've done your risk assessment and you've put everything in place, you've communicated it all to your staff, they are expected to come back to work. If you haven't put things in place and your employer refuses to come back to work for a health and safety reason, then you could have a claim on your hands for detriment or automatic unfair dismissal. Now, the way this works is, if an employee has raised a health and safety concern which is genuine, and you do nothing to address it, and you say, right, that's fine, you're dismissed if you refuse to come to work, that could be an automatic unfair dismissal. If you haven't put measures in place and they refuse to come back to work and you say, fine, go home, but I'm not paying you, that could be a detriment. Just bear that in mind. You need to look at everything on a case-by-case basis, and you need to look at how far the risk is and how remote it is from that employee. Some employees will be chancing their luck, others will have genuine concerns. You need to assess which one they are. Pregnancy, in a nutshell, a specific risk assessment needs to be done for all expectant or new mothers and their children. If their duties are unsafe, you have a duty to find them suitable alternate employment which is not substantially less favourable. If you can't find that, then you need to be looking at things like medical suspension. Medical suspension is on full pay. Health, You've got employees who are clinically extremely vulnerable. They're advised to remain in the home, not to go out to work. They would remain on SSP. Those who are vulnerable are expected to return to the workplace, but you need to treat them in the same way as you would a disabled individual. Look at the risk assessment, what you can do you give them alternate duties, etc. What I would bear in mind is those who are vulnerable would also tend to qualify as disabled in the majority of circumstances. So you do need to look at your duty as an employer to make reasonable adjustments. And finally, look at indirect discrimination. Do you have something in place which puts this employee as a result of their disability at a substantial disadvantage, and you can't justify what you're doing? The other one, which is quite interesting, is those who live with the clinically extremely vulnerable. They are expected to go to work, but err with some caution. You know, you could have an individual who's got a child with leukemia at home. They are not going to come to the workplace and endanger their 5-year-old child. Have a conversation. Can they work from home? Can you do anything to work around? Or do you allow them to be at home unpaid? Common sense is the best thing we can advise you when you're looking at people who won't return to work. Somebody who's just scared, look at it, talk to them. In any of these situations, talk and communicate to your staff. It's the safest and best option for you. You can't make a blanket decision. You need to understand where your employees are coming from. If you can't meet an agreement and you think your employee is being unreasonable, you do have disciplinary sanctions available. You can take them through a fair process, in which case you might get more understanding of where they're coming from. But ultimately, if your employee is being unreasonable in their return to work, you can dismiss, but you need to do that on a case-by-case basis and not use that as your first port of call. That was a very speedy run through of what I think are the key individuals who are refusing to return to work. Not sure if you have any other thoughts, Keith.
I don't. You say it was speedy. It was very thorough, to be perfectly honest with you. I think the key point is the one that you closed on, which is some degree of engagement with individuals. I think that works both ways. I've already had, in the last few days, numerous questions on this exact point, really. And why I say it's helpful from both perspectives. It's helpful from the perspective of the employer and the employee. The key is getting into the detail, really, from an employee's perspective, to understand the challenges they face, to see what bridges you can put in place to allow them to return to work or to accommodate them, which also then flows into the discrimination arguments that Angela was talking about. But for those people where they are reluctant to return, not perhaps for more legitimate reasons, but because actually they quite like their 80% of pay on furlough, and the sun is shining on a day like today, to actually get to the detail of what their problems are, because at times it can be like nailing jelly to a wall. A reason pops out there and then that changes when it's challenged. And as an employer, again, I say to people, don't be afraid to challenge. You're entitled to the premise is that the individual should be at work. If they're not at work, understand the reasons why. And if they are wishy-washy or they don't make sense, don't be afraid to challenge. As I said yesterday to a client, where they said, well, actually, the person said they can't come back to work, actually for childcare reasons at this point in time. But when you actually got into the detail of it, the child was probably able to go back to school because they were in year 6 come Monday, and also then don't be afraid to sort of push against the reasons as to what happens during their working arrangements in the summer holidays normally, because once the school terms are done, we all have a 6 to 8 week window where kids are stotting around as normal at home. And if people will take their summer holidays, correct, but if that employee is normally in during normal working hours, well, why is that not achievable at the current time? Engagement, I think is the watchword. Which, talking about holidays, probably moves me on to the second question. Quarantine following a return from outside the UK. Well, look, what was the real question? I had it up on my phone. Yeah, from July, Spain is allowing overseas tourists with no self-isolation requirements. I'm sure other popular med locations will follow so as to not miss the summer uplift. My concern is on return to the UK. There is still a 14-day self-inclusion period. I feel the company needs a stance on this. How is it to be paid? If somebody books 2 weeks in Spain from July, that will mean a month away from work. What advice can we give, and what are other businesses doing? There hasn't been that much come through on this yet, if I'm being perfectly honest with you, in terms of client questions, unlike the first question. But what I would say is I dealt with holidays during furlough, which was a general update on the ability to require people to take holiday or not to take holiday in one of these earlier Q&A sessions, and they will all be on our website. I suggest you take a quick look at that in conjunction with the answer to this question, because a lot of the general principles will apply. Naturally, you can designate when people take holiday, and taking of holiday is generally subject to operational requirements. I think you are right that you need to plan for this now and get a policy in place, because I think it is reasonable for you to say to your workforce, well, actually, if you're booking holidays at the moment, we want to understand where you are going to take holiday. Is that going to be in the UK, or are you going abroad? Because if you are going abroad, you are effectively, as this individual says, going to be out of the business for a month. And is that reasonable given your operational requirements? Personally, if you can hear clanking in the background, I do apologise, but it is my youngest daughter is baking some cakes. So one of the hazards of dealing with COVID is that we're all at home. My kids are baking. I'm having to run 25 miles a week to stop me looking like a rather large marshmallow. But nonetheless, I'm working hard to stave off the calories so I can keep on stuffing them in. And Elizabeth is continually supplying me with cakes. Anyway, apologies about that. She has screamed apologies in the background and she's being quieter. Coming back to where I was, I think personally it's probably unreasonable in the circumstances, given your operational requirements, of somebody to expect to take a 2-week holiday and then be isolated at home. However, I suppose again it depends on their duties, doesn't it? If they can work at home and they can adequately work at home, it is a damn sight more reasonable than somebody on the production line where you can't staff your normal requirements. I think it's perfectly reasonable for you to have a stance where you ask people when they're booking holidays what they are going to do, where they are going, and therefore you can determine whether it's going to be reasonable for that individual, A, to go in the first place, B, to have this 14-day quarantine coming back. Ultimately, if not, you can refuse the holiday request, in my view. People will say, well, actually, people have a right to take holiday under the Working Time Directive and the Working Time Regulations, and if they're denied their rights to rest and relaxation, that's a breach of their statutory rights. Nevertheless, the reality is that all of those rights are subject to getting rest and relaxation away from work, and that is possible if somebody is holidaying here in the UK. My own view is, I would hope that the government sees sense. It seems like to me that they're trying to shut the door after the horse has bolted, because COVID-19 is in our population and is going to be here for the future. All of the other Mediterranean and European countries are opening up their borders, and people are going to be travelling. It's an impact on business, and if we don't get our economy up and running, a lot of people will be in a lot more difficulty in the longer term, in my own personal view. And I say these are my personal views, and I can see Angela smiling on the camera. I think generally, again, engage with the reasons. If operationally it's not possible for somebody to take a holiday, then a longer period of quarantine afterwards, I think you're within your rights to refuse that application. Don't know if you have anything else to say, Angela.
Hi, I was just mindful of a rant starting there, Keith, so I'm glad you passed over to me. I think it's just key to bear in mind as well that in the quarantine period you would be entitled to SSP. So an employee obviously would be restricted in their salaries. But as well, you know, an employee could take their 2 weeks in Spain and then they could work from home for 2 weeks. That potentially doesn't cause as operational problems as somebody who works in a factory and cannot do their job from home. But absolutely, I think if you cannot sustain an employee being out of the business for a month, you can reject holidays. It's just where we are. And I think with the new track and trace coming in, for example, there's going to be a lot more isolation. You know, if you're contacted on text message saying you've been in contact with somebody who's been declared positive for COVID, then there is another 14-day quarantine period where somebody will need to be at home again on SSP. I think having your employees being out of the business for self-isolation is likely to come up more frequently in the coming months as a result of this. And the whole day question is going to be pivotal, I think, as employees return to work. So our final part of the Q&A is just really a general update, which is probably more Keith having a rant, to be honest. So we've obviously got the track and trace coming in. We don't 100% know how that's going to impact yet. Obviously, much of the guidance is that it should have come in a lot sooner, depending on which party you listen to. But we are not here to pass any judgment on that, are we, Keith? So the way to look at things as well, we're expecting a new announcement from our Chancellor towards the end of the month in relation to how furlough will continue. And Keith and I were having a discussion before this Q&A, and we're both of agreement that don't make any rash decisions, really, until we've heard what's going to happen with furlough. And I'll pass you back to Keith now so he can give you his views in relation to this. Hopefully he's not looking at me blank face thinking, oh no, she's thrown me under the bus. So back to you, Keith.
I think you're right. We're expecting to see a flexible return via the furlough leave, which will allow people to be in work and be at home. The Chancellor's already said there's going to be a contribution from employers. We don't have the first clue what that is going to be or what it's going to look like at this point in time. He did say he would have the updated scheme out by the end of May. So it could come some point today. Realistically speaking, Chancellor tends to do his updates from memory on a Tuesday. So if I'm a betting man, I think it'll be the 2nd of June before he gets something out, and he'll announce it then, and the guidance will follow at some point next week. But I could be wrong. It does happen. Very infrequently, I might add. So there is that. I think the track and trace poses some real challenges for employers. Because it's mandate that whilst it's not mandatory at this point in time, it's voluntary. It could be that an employee gets trapped 2 and 3 times and so keeps having to be sent home to self-isolate for 14 days at a time. What are you meant to do with them? If they can work at home, that will be fine. If they can't work at home, well, they're going to flop back onto SSP again, because the SSP rules are such that they're entitled to be paid if they are ill or if they're being asked to isolate themselves to stop the spread of a communicable disease. So that poses some challenge, and you all need to think about that. I think what has flopped out of all of these 5 weeks of calls, if I could bring forward one major theme, it is probably like anything in the world of employee relations. It's talk to your employees, understand, listen to them, try and be accommodating before you make decisions. That doesn't mean that you can't make hard decisions that the business requires. It just means you have to take that pause for breath, engage, and then make the decisions based on what you know. Angela, I don't know if you have anything else to add, just to lob it back to you, or have I missed anything along the way?
No, I mean, I think that kind of covers where we are. Communication is key. Employees will come to you with a very generic statement, and you need to kind of unpick it, really. It's the same as if you were to undertake disciplinary action. You wouldn't make a decision based on the initial gut that someone, for example, has stolen from a till. You would always go and investigate. And it's a similar circumstance here. Understand, talk, communicate. And like Keith said, you know, it's not just about the employer understanding the employee, it's about the employee understanding the employer as well. So we need to understand we've got communication going through, and there's got to be some flexibility. We are in unprecedented times, which is probably the most overused word following furlough in the last few months. And that's just where we are. I agree with Keith. I think Rishi will probably give his update on Tuesday. He has said by the end of the month, but we'll see where we go. And then we'll have an understanding as to how the part-time coming off furlough scheme will work, how the contributions will factor in, etc. But I think that's all from us. And I'd just like to thank everybody for tuning in over the last 5 weeks. And just to let you all know that we do have another seminar coming up on the 18th of June, I think. If I'm incorrect, David will correct me in a couple of minutes. Okay, I'd just like to say thank you from all of us on the employment team. Thank you.
Thanks, Keith and Angela. Just a reminder, we are working hard to produce and deliver useful and relevant content to you at this time. Articles, blogs, podcasts and videos, all of which can be found on our website, www.sintons.co.uk, should you wish to take a look. And in about 15 minutes, that will include all of the Q&A sessions, so you'll be able to replay those at your leisure. Twitter, you can follow the employment team on Twitter at SintonsHR, and there's lots of great updates the team regularly put out on social media, so have a look at those as well. I've just popped the speakers' details on the screen. If you'd like to discuss anything they've raised today further in this or any of the other sessions, please do get in touch. Details, like I say, are there. If it's any other legal inquiry, obviously please to get in touch as well. All that's left to say is from Keith, Angela, myself, Elizabeth baking in the kitchen, also from Ailsa Hobson and Catherine Hope from our previous sessions. Once again, thank you very much for tuning in, for listening. Keep staying safe, everybody, and we'll speak to you again. Thank you.